Hi, everybody. I am Michelle Morris from Consolidated Planning Group. Thank you so much for joining us. We have a great topic today. We're going to learn about guardianship and alternatives to guardianship from attorney Alison Packard. She's got a great presentation for us. First, I'm going to go through the rules of the road, kind of the housekeeping items. We are in webinar mode, which means that we cannot hear you or see you, and I won't be unmuting anybody. If you have any questions or concerns or comments, we want to hear them. So please put them in the chat box, and that will allow us to present and see the questions and kind of bring your questions into the presentation. I know some people have submitted questions beforehand, and we're going to get to as many of those as we can as well. The other thing I want you to know is that we do record all of our webinars and we put them on our YouTube channel. So if you're interested in checking that out, I've put my contact information and a link to the YouTube channel in the chat box, and you can go ahead and find that there. And I will actually do it again. Um, so we should be here for about an hour. Go ahead and enjoy your lunch or snacks or drinks or whatever, because we can't see you anyway. Kara Huss from Williams School has joined us, and she's going to tell us a little bit about Williams School before we get started. So Kara, would you like to tell us about Williams School? It's in Austin, right?
Yes, ma'am. Thank you for having me here on this webinar today. I'm excited to learn along with everyone else on all the great information that's going to be shared today. So yes, my name is Kara Hess. I'm with Williams School. We are located in Austin, Texas. You'll see on your screen there our mission, providing a unique education for unique individuals and supporting neurodiverse individuals in their unique progress, focusing on confidence, independence, and connectedness. We serve individuals from 2 to 22. So you'll see a little bit of that wide range here. And our beliefs there that given the right supports, all students can thrive. So we run traditional school hours with a half day on Friday, a pretty traditional school year calendar as far as the holidays and vacations that you would typically see in an August to May calendar. And then we extend on for a 7-week summer camp with a session in July and a session in June, a session in July. That's open to both currently enrolled students and students who are enrolled elsewhere during the school year. So often asked, who do we serve? I mentioned the age ranges. A lot of our population has autism and other neurodiversities. So we see ADHD, ADD, ED, Down syndrome. Overarching, typically we're seeing students who are really struggling with that traditional classroom setting. Typically those struggles we see are communication, social, behavioral. Sometimes that is trauma or PTSD or learning difficulties, but all of those things are really inhibiting their ability to be really successful in that more mainstream traditional setting. And the other thing that we have that's a little bit different is that we have clinical services on site full time. So we have speech therapy, occupational therapy, and ABA behavioral therapy on site. So we really are taking a collaborative approach using that multidisciplinary team to make sure that everyone is bringing that expertise to the table and really thinking about the whole child and how do we put all of that knowledge together to make sure that our students are thriving and learning and moving through their educational journey. So for those that maybe are looking for everything kind of in one spot versus having to constantly pull everyone together and constantly taxi from one spot to another, because I know many of you spend a lot of your day doing that. So I mentioned the age range as well. Students based on learning styles and their support needs and within an age range. So we currently have 9 classrooms serving 52 students. Our student support varies from 1-to-1 to that 1-to-4, really depending on the need. Our classrooms are typically 6 to 8 students, all of them with a lead teacher, a teaching assistant, and some classrooms that have a second teaching assistant who's also a behavioral technician to provide additional support in the classroom. And then I mentioned that collaborative approach of the school team and the clinic team really working together day in and day out to make sure that students are being successful. Some other things that make us unique from maybe more of your kind of traditional school settings, we're accepting of all behavioral support needs. So we see students with any range of support level, as long as we have the team and the physical space at the time. Individualized curriculum. So as I mentioned, we have the age band in our classrooms. We're really focusing on a developmental versus an age-based grade placement. So where is your student now? Where do they need to be? And how do we get them to that point, whether that is moving through curriculum quicker than a traditional pace or slower than a traditional pace, or focusing on the pieces that are most functional or the pieces that are most relevant to whatever it is that your goals are, maybe for your loved one and their time with us. And then a really proactive focus on the social emotional piece. So really dedicating time to teaching those skills up front and really building their rapport and really building that trust versus just reacting to things after they happen, but really getting down to that core need and figuring out what skill deficits are there that are leading to those challenges when they're interacting with others. I mentioned that team, and some of these are even grown. Need to update these slides, but we currently have 9 teachers and close to 12 teaching assistants, those TA RBTs I mentioned, and then we have our clinical team, registered behavior technicians, board certified behavior analysts, speech pathologists, and occupational therapists who are on site full time as well to support our students. Our enrollment process, you'll receive these slides when you're done, and most of this can be found on our website. But this kind of gives you an outline of how our enrollment process starts. And then our therapy dog, Granita, who's also here with us full time, is a great end to the slide. But she helps a lot with transitions and anxiety and
What's her
kind of
name
helping
again?
kids get through their day. Granita.
Granita. Okay. And
there's
your
our email there. If
contact
you have
info.
more questions, feel free to also put your questions in the chat, and I'm happy to answer them there. But we'd love for you to reach out to us if you have any additional questions, or if you think that our program might be a good fit for your student.
I just want everybody to know that there's a comment in the chat box. It just went, oh, there it is. It went out to everybody. My kiddo has been at Williams School for 4 years. Best experience. He loves it. Kara is phenomenal. The teachers and therapists are amazing. That's from Jessica. So if you have questions about Williams School, please reach out by email. Kara, if you would like to share any other contact info in the chat box, you certainly are welcome to do that. So Consolidated Planning Group, we host all of these webinars. We do these 2-3 times a week usually. And why? Because we are a financial advisory firm that focuses on serving families with a kiddo who has any kind of intellectual or developmental disability. We're located just outside of Houston, and we work all across Texas and all across the United States. We've been in business for over 30 years, and we are top of the table, $1 million round table. That's one of the kind of industry awards that we have won through the life insurance and securities and investments, things that we do on that side. We're also members of the Special Needs Planning Academy. We are nationally certified as Social Security advisors, and I'm a chartered special needs consultant through the American College of Financial Services. So really, almost every client that we serve has an individual in their life with some kind of disability. Families really come to us for things like planning for the future. How are you going to protect your family? If something goes wrong and you or the main breadwinner in your household can't work, that's going to cause a big issue. Lifetime care planning. We talk about transitioning a lot from high school to what happens next, to moving out, guardianship, what happens at age 18. We can help you with ABLE accounts and understanding different avenues for being able to have money for your loved ones. And then, of course, we're here to educate you, advocate for you, and educate you. It's a new word. I made that one up. You know, there are over 263,000 financial advisors in the United States. And out of those 263,000, you're probably having a really hard time finding any financial advisor that understands the nuances of special needs planning, because only 200 or fewer focus on this topic. It's less than 0.1% of all the financial advisors in the United States really focusing their efforts on helping families like yours. So you're in the right place. A few bits of advice, and I'm going to let Alison take over because you're here for her, not for me. We always say, think ahead about the future. Start your planning now. Doesn't matter how old or young your child is. Get on board with thinking about the future and planning out what's going to happen after high school. Will your child live? And when are they going to make that transition into their next residential living arrangement? Is that going to be with you until you pass away? Well, what happens after you pass away? Is it going to be that they're going to go to a school or a residential community, or a sibling is going to allow them to move in? Think about what's going to happen after high school, what's going to happen further down the road in their life, where are they going to live? And if you think that a sibling is just going to be the easiest answer, think long and hard about that and have a lot of discussions with your children and siblings and make sure that that's what you want and what they want. Okay, so enough from me. I know you're here to listen to Alison Packard. She's got some great information about guardianship and alternatives to guardianship. So I won't take up any more of your precious time, Alison.
Thank you for having me. I really love these seminars and or webinars, I guess is what we are. So guardianship is a state program. So I'm going to be talking about Texas rules, Texas law today. And it looks like most of us on the call are Texan. If you are from another state, it's going to be similar, but there might be slight differences. But we'll focus mostly on Texas law. Oh, this is just a quick introduction of me. I work out of San Antonio at the Packard Law Firm, and I do a lot of guardianship work, special needs estate planning, special needs trust, some probate work. My main qualification comes from being mom to a daughter with special needs. I think that's how we learn most of the great things that we learn are fighting for our own kiddos and trying to understand the system, which can be confusing. What I'm going to tell you today, by the way, is not specific legal advice for anyone in particular. That's a standard disclaimer that lawyers always give. We're just here to give educational information.
And I want to remind you guys that not every attorney is created equal. Just like there's very few financial advisors who understand the nuances of special needs planning, the same goes for attorneys. Not all of them understand these things. So we refer clients to Alison all the time, and we keep a list of great attorneys like her who are able to focus their practice on special needs families.
Thank you, Michelle. Let me just go back to a broad overview of guardianship. Most guardianships are created for elderly people who didn't have powers of attorney in place. They have a lot of money and now they've lost capacity to manage their money. That is the great majority of guardianships in Texas. That's not necessarily going to be our main focus today. I think today with the audience, it's families like mine where we might have a child with developmental disabilities who's now an adult, and we need to have rights. We need to make sure we have the ability to make decisions for that child. But just to understand the system, if you have a broader view that most guardianships are, the system is built to protect the elderly with a lot of money. So you're going to see that guardianship is very court intensive, very expensive, lots of protection. It makes more sense if you think about it in terms of grandma who has a big bank account and the courts want to protect somebody from swooping in and taking over grandma's money, if that makes sense. Guardianships, again, they, besides being for the elderly, who people who have lost capacity and didn't have powers of attorney or some system in place to let someone make decisions, we also do guardianships for minors. As parents, you know, we have the right to make decisions for our minor kiddos. We can make medical decisions, choose where our kids live, make educational decisions, religious upbringing decisions. We have the right to have physical possession of our kids. But surprising to a lot of people, we actually don't have the right to manage our minor children's money. So if our children inherit from grandma, or you know there's some kind of lawsuit settlement, just because we're mom and dad doesn't mean that we have the right to manage that money. So we do a lot of guardianships for minor children. And we're not going to focus on that today either, other than to say, you know, if you have estate planning done, if you were to pass away before your children are adults, it's very easy to put a simple trust clause in a will that says if my children are minors, have the money go in trust until they reach a certain age. So a lot of times there are ways we can avoid these guardianships. Again, for the elderly, it's through powers of attorney, that are signed before the person loses capacity. For minor children, we can have trust created under wills. We can make sure to look at other alternatives. And that's an important concept in the guardianship world. We always try to avoid a guardianship if possible. And so we look at other alternatives. Now, if we're talking about, and this is our focus for today, someone with a developmental disability, then we have to really get into their capacity. Basically, if you have someone with a developmental disability who is now an adult, we've got a few options. One, we don't do anything. We leave that adult child to just represent himself or herself. Another, we go to guardianship court and get a guardian appointed to make decisions for that now adult child, or we look at less restrictive alternatives. In Texas, the guardianship process is in the courts. It's not just a paper you sign. You might sign a paper that identifies who you would want to serve as guardian of your child, or I can sign a paper saying who I want to be my guardian if I ever needed that. But to have the guardian appointed, it involves a judge. And so the court process is where the judge makes a finding that this person is incapacitated. So either they're a minor or they are an adult who, because of their physical or mental condition, they are now substantially unable to provide food, clothing, or shelter for themselves, care for their own physical health, or manage their own finances. And so the judge determines that incapacity and then determines who the right guardian should be. Now, it's important to understand that determination of incapacity is not the same as Social Security disability. That's different. This is a different standard. As you probably know, and I know there are lots of webinars on Social Security issues, disability with Social Security is more related to the ability to provide enough, to work. It's basically engaging in substantial gainful activity. It means, can you work and earn enough money? So a lot of people receive disability benefits, yet they are not found to be incapacitated through the court system. Okay. Incapacity in the court system for guardianship purposes is really dependent on medical evidence. And there is a set form that is used all over Texas, no matter which county you're in. It is called the Healthcare Provider Certificate of Medical Examination. And every few years, sometimes many years, this form is updated. So what's on your screen is the latest. It's just one page out of the latest version, which is September 2023. If you find an old physician's certificate of medical examination, that is not going to work. The form is too old. So you need one that says Healthcare Providers Certificate of Medical Examination. We call this the CME. And in this form, the doctor, or it could be a nurse practitioner with the oversight of a physician licensed in Texas, that physician fills out the form and identifies the diagnosis of the person that they're evaluating, and also indicates what ability this person who may be under a guardianship, what abilities they have to vote, to make their own decisions about getting married, to decide where to live, to drive, to make their own medical decisions. And so if you are looking at guardianship, you want to be very familiar with this form, because this form is going to dictate what type of guardianship you have. All right, and can you go to the next slide, Michelle? And I would say focus on question number 5. In Texas, it is possible to have a limited guardianship. You can have a full guardianship where the person who's appointed guardian makes all decisions, but in some cases, a limited guardianship is appropriate. So perhaps the individual who's going to be under a guardianship, we call that person a proposed ward. It's not the most flattering term, but that's what we use. Perhaps they are capable of voting, but they can't make their own medical decisions or choose where they should live, but they really want to retain the right to vote. Well, if you work with your doctor and the physician feels like this person could vote, then they can indicate it on the form, and that leads to a limited guardianship where some rights are retained. Now you got to be careful with this. You know, if your doctor is saying that your child has capacity to do a whole lot of things on the list, then the natural response of the judge is going to be to say, well, why are we doing a guardianship? You know, if we're only looking at a couple of minor areas, maybe we don't need a guardianship. So if you're looking at a limited guardianship, you almost need a story why your child or the person under the guardianship needs some oversight in some areas, but not in others. I'll give you an example. Somebody who is not making good medical decisions. Maybe they are afraid of the doctors. They won't have tests run. They won't have their blood drawn. Maybe they have significant medical issues, or they might need someone to take over the medical decisions. Or a different situation would be somebody who is making very bad decisions in their social life. Maybe, I recently had a case where someone was associating with a very unseemly character who wanted to basically get her out of her house. And so we did a guardianship just to remove the right to get married and choose where you live. So if you've got a certain story, we can tailor the guardianship, but it needs to be done with the doctor's support. You can't just say these are the rights I want to keep and these are the rights I want my child to keep. You need a doctor to support the fact that this child, now an adult, is capable of making those decisions. Okay, so it's very dependent on the medical evidence, and this form needs to be completed by somebody who's used to evaluating incapacity or has been treating your child for quite a bit of time. That's on the first page of the form. Read through.
So this is not for parents to fill out.
That's exactly right. This is a medical form. Now, I advise you to be familiar with the form and know what you're hoping the doctor will state on this form, and in case you need a conversation about it. And my office also has a tip sheet, which I can send to Michelle to give to your doctor, because you need this form to be filled out accurately. Otherwise, the court is going to send you back to get it fixed. Okay. We've already touched on the items on this slide as far as you can have a full guardianship or a partial guardianship, but understand that if it is a full total guardianship, then the individual under the guardianship, the ward, we would say, now loses his or her right to vote, to get married, to make decisions about where they're going to live, to make their own medical decisions, consent to dental treatment, psychological treatment, to drive, to own a gun, and to make their own educational decisions. And in many cases, that's exactly what needs to happen, because perhaps we're dealing with an individual who really can't make their own decisions in these areas. But you'll notice that these are very basic rights. And so the thinking in Texas and in our disability community is we need to be careful before we go remove these rights. We need to really look at whether or not this is necessary. And so the court has all kinds of safeguards in place to make sure we're not just taking away rights from somebody who should be able to keep some of those rights. And some of those, we'll get into that, but there is an attorney ad litem who's appointed to represent the person who's might have their rights taken away. A lot of courts have investigators. So we'll get into that in just a minute. And as I already mentioned, what's on this slide, which is we can have a limited authority guardianship or a partial guardianship. In Texas, we have guardianship of the person and guardianship of the estate. Guardianship of the person is when you have an individual named who will make medical decisions for the ward, choose where the ward lives, make educational decisions. It's more of the personal decisions. Guardianship of the estate is managing money. The guardian of the estate would have the right to manage a bank account, make decisions about settling a court case, a lawsuit settlement, those kinds of things. Recently, about a year ago, we had a little bit of a new type of guardianship. It's a hybrid of the two of these. It's a guardianship of the person with the right to manage up to $20,000 per year. And so this is a little bit new, and not everyone is familiar with this. But if you have a child who is just earning a tiny bit of money, maybe a very part-time job, maybe summer earn and learn program, something like that, you can now manage that money as a guardianship of the person if the total does not exceed $20,000 during the year. Okay. And if you do that, you're going to report on that every year, what's happening with the money, but you don't need the guardianship of the estate. The duties of the guardian of the person. I'll let you go through these slides in more detail when they're sent to you, but basically it's sign whatever documents are needed, consent to medical treatment. You are responsible to have physical possession of the ward or to determine where the ward lives. So if you are a guardian, it does not mean that the ward has to live with you, but you are making the decisions about where that person lives. And this is really important, as Michelle mentioned, when we look at siblings possibly taking over for parents, it's important to have these really good conversations. And perhaps the sibling's not the right choice to be a successor guardian, or if they are, perhaps they're choosing for their sibling to live in a different place, but they're making the medical decision. So it's very personalized what the right situation is for your family. A guardian of the estate, as I mentioned before, this is going to be dealing with the power to spend the ward's money, to invest the money, but it is not something where you just get appointed the right to manage money. You're appointed that right, but you have to go back to the court for permission to spend money. You can get some things pre-approved, but like if I wanted to go on vacation and I was a guardian of the estate, I could ask the judge to approve of certain expenditures, or maybe we need a funeral plan. We want to buy a prepaid burial plan or something. You can get permission from the judge, but you don't have the right to just spend the money as you wish. And every year as a guardian of the estate, you have to do an accounting of all of the money. And this can be quite an expense. You have to have a lawyer in almost all counties in Texas. They're requiring an attorney to do the accounting. So you're looking at legal fees forevermore if you're a guardian of the estate. It's expensive. And as well as any kind of, action you want to take as a guardian of the estate. What's very common in my world is we will apply to the judge to move money to a special needs trust. And you have to actually, even though it's an obvious thing that is in the best interest of the ward, we still have to go to the judge and ask permission. So it can be very expensive to be a guardian of the estate. And we try to avoid that where possible so you don't have ongoing fees.
And I see the last one here, the duty to close it out when it's no longer needed. I received an emailed question, one of our clients asking, why do they make me fill this out every year? Well, it's because of that, right? I mean, you got to make sure that the person still needs it.
Yeah, so I think we have some slides later on, but let's jump to this right now. If you are a guardian of the person, you're going to need to file an annual report. So you have guardianship letters that actually expire every year. You're still the guardian, but you're out of compliance if you don't renew your guardianship letters. That, for guardian of the person, it's a very simple form. It just explains to the court where this person is, what their medical condition is. And I agree, it feels like such a pain for parents especially, but think of it after you are gone. You want the court to know where your child is. You want the court to make sure that that individual under guardianship is safe and protected. And so this is the way for them to kind of keep tabs on someone under a guardianship, to make sure they know what's happening with that person. In many counties, there will also be an annual visit. That doesn't happen in every county, but it's not personal. It's just the judge trying to make sure that their people in their county that are under guardianships are safe and protected. Now, for guardian of the estate, that's going to be the big financial accounting as well.
Mhm.
And that again is the court system trying to protect someone who doesn't have the ability to know what's happening with their money. We want to make sure that no one is just stealing their money. Okay. Guardianship of the estate considerations. To be a guardian of the estate, you have to qualify for a bond, and that means you're going to have pretty good credit. If you've got really bad credit score, you may not be eligible to be a guardian of the estate, even though you're a parent. And you're going to have to renew that bond. The amount of the bond depends on how much money you're managing. And I already mentioned it's a lot of legal fees. And so we try to avoid guardianships of the estate where we can. And we do that by making sure money is managed in other ways. That's where we look at less restrictive alternatives. And I'm going to let you just go through these slides. Yes, guardianship reform, it's been a few years now, but the main thing Texas is really focused on is, can we find an alternative to this guardianship? Can we avoid taking away all of these basic rights from this individual? Is there another way to support them? So we want to look at all of those options before we go off to court. And if you don't look at it, you may be in the court system and the judge or the attorney ad litem might say, we don't need this guardianship. There's an alternative. So some of the basic alternatives to guardianship of the person would be powers of attorney and supported decision-making agreements, a declaration for mental health treatment. Let's look at these powers of attorney a little bit more deeply. For a medical power of attorney, if you want to go to the next slide, Michelle.
Oh, there we go.
A medical power of attorney, this is where someone with enough capacity is naming another individual to make medical decisions for that person when they lose their capacity. Okay. And the doctor's going to say when this kicks in. So what I mean by that is since I'm thinking clearly and can make my own decisions, I can sign a document that says, hey, if I lose my ability to make my own medical decisions, I want my husband to make them. Or if he's not around, I want this child or my sister. Or, I can name anyone I want. And so to sign this document, you have to have the ability to understand what it is you're signing. So this is a great option for a lot of people, but it doesn't work as an alternative for someone with disabilities who's very low functioning and doesn't, has a lower IQ. They're not going to understand this document. For borderline cases, we need to remember that if you have the capacity to sign this document, it means you have the capacity to make your own medical decisions. You have the capacity to revoke this document and say, well, I used to have my mom as my medical power of attorney agent, but now I want it to be my boyfriend. Or now I want to make my own decisions. And all the person has to tell the doctor is, I don't want this person to make decisions for me anymore, and it's revoked. So it's a great option to avoid guardianship, but you need to understand that it means you are saying that this individual has capacity to make their own decisions. Okay. And another kind of power of attorney, going back to this last one, I wanted to make one more point. The medical power of attorney only kicks in when the doctor says there's incapacity. So if your child signs a medical power of attorney, it doesn't mean that you as a parent are making medical decisions for them. It just means if they're in a car wreck or they lose their capacity or the doctor determines that there's not enough incapacity anymore, then that's when the power of attorney agent starts making decisions. Okay. Durable power of attorney, this is related to more than just medical. This would give someone the ability to make decisions related to school, vocational training, signing contracts, a gym membership. It would be finances, managing a bank account. And this is where we see these used all the time. And all of us, by the way, should have these powers of attorney because there's a high likelihood that any of us can lose our capacity in the future, whether it's just the normal aging process or an illness. But if I have a power of attorney and I say my husband is my agent, then when I lose my capacity, he can sign for me. I don't need to be placed under a guardianship. This kind of power of attorney with the finances and things like that, this can be effective immediately. Or you can say only if I lose my capacity. So again, to sign this document, you have to understand what you're signing, but it certainly does avoid a guardianship in many cases if the individual has enough capacity to sign this document. And these are very inexpensive documents. If you use an attorney, you may spend a few $100s. In Texas, there are a lot of samples online. Texas Supreme Court has some sample forms. I always advise going to an attorney's office, so I don't want to discourage you from that. But there are ways to get this done much more cheaply, of course, than a guardianship. But if someone comes to my office, and I've had this happen, unfortunately, if the individual does not have capacity to understand what they're signing, then we can't sign it. And that is one advantage of going to a lawyer's office. If you have a borderline case, you'll have an attorney who will vouch for the capacity.
Does this protect people from, if your child is talked into signing a contract to do something that they shouldn't have signed, would this protect them?
No, that's a great question too. When your child signs this, you're now adult child. I'm assuming that's mostly what we're talking about.
Yes.
an adult child, and I have a daughter, by the way, we mentioned earlier, who's in 30, and she's still my child, so even though she's clearly an adult. When they sign that, then we are all acknowledging they have capacity to sign documents. So it doesn't prevent them from signing another document or revoking it or choosing a new power of attorney agent. So no, it does not stop someone from making their own decisions. It just means that that person could step back and say, I want my power of attorney agent to sign for me. Okay.
And once you fill this out, does it just need to be notarized, or does it have to be filed, or?
It doesn't need to be filed. I mean, if you're using a power of attorney to sell property, then there is going to be some recording in the property records. But otherwise, no, you just keep the documents. They do need to be notarized or signed in front of witnesses. And so depending, like the medical power of attorney, for example, could be signed in front of 2 witnesses or notarized. So it just depends on the document. There's also a document, a supported decision-making agreement. This is a document where an individual with disabilities signs something stating that they need a supporter. They want to make their own decisions, but they want a supporter to be allowed in the room to help explain what the situation is, help them make a medical decision, for example, or help them before they sign a contract. So this supported decision-making agreement does not give the supporter any rights to sign for the individual with disabilities. It just gives them the right to say, hey, let me explain this to you. Let me tell you my thoughts. Let me help you communicate. But in the end, the person who makes the decision is the individual with disabilities. You know, so this is effective in some situations and not as effective in others. For example, some doctors apparently want a parent to have this document before letting the parent come in the room. I'll be honest with you, my daughter has a ton of disabilities. I've never had a doctor kick me out. And, you know, so in some cases, the doctors don't really require this to let a parent be involved, but in other cases, school situations, a lot of times this is effective to keep parents involved. Or I say parents, it could be a sibling or a grandparent or child. Okay. And the theory behind this is just that somebody with disabilities might need a little extra time to learn how to make good decisions, but they can get there with practice. So we need to let them practice. We just need to give a supporter to give them guidance in making these decisions. Because we all know we were all 18, 19 once. We all make dumb decisions. And so we've got to allow some leeway for people to learn how to make good decisions. This document, the supported decision-making agreement, is super simple. You can find samples of this on all kinds of websites. Disability Rights Texas, the ARC of Texas. There's lots of websites that have good supported decision-making agreement samples. You can also go to an attorney's office, but this was a little more of a basic document, just lots of yeses and nos and who am I choosing and what do I want them to do. Okay.
So what makes this, or is this legally binding at all?
It is legally binding. It basically is giving you as a supporter the right to be involved in an appointment, in a school meeting, in a medical appointment, in, you know, talking to the banker. But if the agency, the school, feels like you as a supporter are manipulating your child or taking over or pressuring them, then actually the agency has the duty to report this. So, you know, it certainly is not giving the supporter the legal right to take over decisions, just to be involved and help counsel. And I think it's a great document. In my personal life, I haven't had to use it very much. There was only one time where it was really effective, and my daughter was in a school program that was just too hard, a community program. And I said, tell them you have a supporter, wait till I get there and we'll talk it out. And that was effective. Otherwise, typically I just don't need it, but a lot of people have used them and they really like those documents.
Yeah,
okay. Let's go to alternatives for guardianship of the estate. Most of us on this call can typically find an alternative to avoid a guardianship of the estate, which is great because it saves a lot of money. Again, when you're under a guardianship of the estate, you are looking at ongoing legal fees. And so it's very expensive. So
before we move on, can we do both of those POAs without an attorney if we have to?
Yes, You can. The value of an attorney would be an attorney has to vouch for capacity. So my only caution, if you're doing it without a lawyer, is if it's borderline capacity or someone might not be sure this person who signed the power of attorney really understood what they were signing. It's just because you have a power of attorney doesn't mean someone needs to accept it. And what I have seen, unfortunately, is a parent will have their child sign a medical power of attorney, and then when there's a medical emergency, the physician says, your child did not have capacity to sign that. We're not accepting this. So go get a guardianship. And now go get an emergency guardianship because we have an emergency situation. So, that would be the advantage of the lawyer to vouch for the capacity, but you certainly don't have to have the lawyer do it. Okay. And there are plenty of forms available online. Let me just say this. If you're going to do the power of attorney, I recommend a statutory durable power of attorney, medical power of attorney, HIPAA authorization, supported decision-making agreement. Those would be kind of the basic 4 documents that I would look at. If the supported decision-making agreement is too complicated, if the statutory durable power of attorney document is too complicated, you could do a simplified power of attorney document. So those are kind of the basics I would look at. Okay. Again, we're talking now about alternatives to guardianship of the estate. So this is how can we avoid getting that very expensive court oversight, having a judge look at everything we do. The most obvious alternative that applies to many of us is we become representative payees to manage our children's Social Security payments, whether it's SSI or SSDI for our child or for our parent. They have a system in place where you do not need to be a guardian, but you can just be named as the person to manage the money. And it's actually pretty easy to get appointed. Social Security Administration doesn't take powers of attorney. They will look at your guardianship letters and they will see that this is who the court thought was the right person to, but they'll still have that person be named as a representative payee. And then you go open a representative payee bank account and you have the authority to manage the person with disabilities manage their money, if that makes sense. So in my case, for my daughter, she does receive SSI, and on the bank account it says Alison Packard for Angela Packard, and we're both on there, and I get all her letters from Social Security, and I don't need a guardianship of the estate to manage her Social Security money. Very simple process. It's very common for someone who becomes elderly with severe disabilities that someone can be appointed as rep payee to manage their parents' retirement funds. But in our world, we're looking at SSI and SSDI a lot.
One thing about being a representative payee that a lot of people don't know is you definitely want to sign up successor rep payees under yourself so that if you pass away, there would be a pause from the Social Security if they don't know who the new rep payee is. So I think you could name 3 or 4 people behind you so that if you pass away, the next person just automatically is put into place as the successor and those benefits won't lapse or pause.
Yeah, that's a terrific point, Michelle, because otherwise, a lot of times those payments are frozen and you're waiting without that payment that you need. Yeah, thank you for adding that. Another alternative to a guardianship of the estate is a trust, and we could talk for an entire hour on the value of trust, especially special needs trusts.
And we've got webinars about that.
Okay. And I encourage everyone on this call, if you're considering a guardianship, you definitely need to consider a special needs trust. So I encourage you to listen to those webinars. But a trust is where you have someone managing money for the benefit of a beneficiary. A lot of trusts, I can be a trustee managing money for myself as a beneficiary, and I might do that to avoid probate. That's a whole different topic, but a special needs trust, if you want to go to the next slide, this is a particular kind of trust that allows somebody to manage money for a beneficiary who is disabled, and it's very particular how this trust needs to be written, but it avoids all the money in that trust account does not disqualify someone from receiving needs-based government benefits such as SSI and Medicaid. So again, there's too much to cover right here, but you should just know if you create a will or you name payable and death beneficiaries and you leave assets to a trust rather than to your child with disabilities outright, it's going to help avoid a guardianship of the estate. So this is important to understand. So let me elaborate a little bit more. So if I have a life insurance policy and I say, when I die, if my husband's not alive, give it to my children, then my daughter's going to inherit money in her name. And now someone's going to need to be appointed a guardian to manage that money because she can't manage it herself. But if instead I name her special needs trust, I don't need to run to guardianship court because now I have a trustee who can manage those funds. Okay. And there's some slides that give a little more detail. There are first party trusts and third party trusts, and it has to do with where the money's coming from. If you have questions, watch those videos. If you want to reach out to me, I can send you a whole slew of information about special needs trusts. Okay. Okay, I'm going to keep going. How long does the guardianship process take? That is going to be dependent on the county that you're in. So if you've gone through all these alternatives and you say, you know what, my adult child cannot sign these documents, we need to have a guardianship, then depending where you live, I would say anywhere from typically 4 months up to 6 months. Sometimes we can get it done in a couple of months, but it's not a couple of weeks. Okay. The fastest, other than an emergency situation, which we can get a guardianship done in less than 2 weeks, but that's expensive, and you're basically paying for a temporary guardianship and then a permanent one. So if you're not in that emergency situation, we've been able to get them done in a month, but that's rare. Usually it's at least 2 months, more typically 4 months, and then depending on other issues, it could be 6 months. Okay. You can file your application up to 6 months before the 18th birthday of the person who's going to be under guardianship. Okay, but no sooner than that. And remember that CME form we discussed earlier, you have to file your guardianship application within 120 days of the date that the doctor examined the proposed ward, the person who's going to be under a guardianship. Okay, so there's a timing issue. So you don't run out and get the doctor to fill out that CME at age 17 because you can't file it soon enough. You got to wait till your child's about 17 and a half or so, get the doctor to fill it out, but you can file the application early. Okay, the guardianship is filed where the proposed ward resides. Sometimes if we're looking at money, we can vary the county. But so if your child is living in a group home, you would file it in the county where your child is living, not where you are living. Okay. I mentioned a temporary guardianship. This is a situation where there are emergency medical decisions that need to be made. An example of that would be, it's been a while since I've done one, but someone needed ECMO treatment during COVID, and the individual unfortunately turned 18 while she was in the hospital, and we had to get an emergency guardianship because it was a very difficult emergency treatment, medical decision, I'm sorry. I don't want to scare everyone. If your child is not under a guardianship and they have an emergency situation, they're going to be treated. It's more of the decisions that could be controversial. A lot of times the doctors want to have someone with legal authority making any decision that is, where there could be a tough decision made. Okay. The process, we're going to whip through this, but basically you get the CME completed, you file the application. The person who's going to be placed under guardianship is served a copy of the application. Someone from the sheriff's office knocks on your door, hands the copy of the application, and they are served. You also have to give notice to immediate family members. Now, the family members can also sign waivers, but you'll see this is starting to add up the cost. Just to file the application in many counties, most counties, it's over $500 in court fees just to file it. Some counties have the attorney ad litem fees already built into the initial filing. Travis County, I know there's a lot of people in that area on the call. It's over $1,000 just in the court cost to start the guardianship. That's not your attorney's fees. That's the cost to file. And so the more you can get family members to sign waivers, avoid service, all of that adds up. You have to, if you're going to be a guardian, you have to have a criminal background check done. You register with an organization, and they run a background check on you. Sometimes it's fingerprinting if you're doing a guardianship of the estate, or if you're a guardian who lives out of state, they actually fingerprint you. Otherwise, it's something that you just get, your name and social security number check. If you have have a criminal history that is concerning, you may not be able to be a guardian. Again, even if you are mom or dad, if you have felony convictions or if you have a history of violence or neglect, that could also include child protective services, validations. The judge has a right to say, no, I'm just not comfortable naming this person as a guardian. But if you have a criminal history that concerns the judge, you won't be appointed as guardian, regardless of your relationship, okay? Attorney ad litem, I mentioned, is appointed every guardianship before we take away those rights from that proposed ward. They're going to get their own attorney appointed to represent them. That attorney is going to go out and visit and make sure that this guardianship is necessary. And that attorney ad litem is paid, and guess who pays? It's the person who files the guardianship application. So that's adding another typically $600 or more. I can't give you an exact amount on that. I've seen it as low as $300, and I've seen it over $1,000 in an uncontested guardianship. Now, if there's a fight going on between, say, mom and dad, who the right guardian is, this attorney ad litem fee could be huge. It just depends on the individual. But I would say typically $600 is a good estimate, although it could be higher. The court investigator, if there is one in a statutory probate court, they file a report, and you have a hearing after the child turns 18, and then the person who's appointed as guardian signs an oath and gets a bond, and you're officially the guardian. Then every year you just renew that guardianship. We won't get into these additional steps for guardianship of the estate just because of the time, but I already mentioned you are going to be doing a lot more work with the court. You're going to have a lot more legal fees because you're going to have to report regularly on what's happening with the money. Okay. Do you want to go to one more
There we
slide?
go.
Oh,
I tried. Yes, there we go. So who can be the guardian?
yeah, the judge is going to give deference to the closest family members, and that just makes sense. So if there is a child or a parent, then of course they're going to have a right to be guardian over somebody else. And so there is an order based in the law, but if you sign a document saying, or in your will you say who you want to succeed you as guardian, that is going to be the ultimate precedence. So if I say, when I'm not alive, if my child needs a guardian, I want it to be this sister, or I want it to be this agency, or whatever, the judge is going to look at that first. Now, the judge doesn't have to agree with you, and you still need a quick court hearing to make sure this new person doesn't have criminal history, make sure they can get their bond and things like that. But the judge is going to always defer to what the family member recommends, okay? Otherwise, there's an order of closest relatives first. You can both parents can be appointed as co-guardians in Texas, but the law in Texas is that you need to be married to be a co-guardian, or you need to both be the parents of the proposed ward. If you're coming from another state, you could have a mom and a sibling as co-guardians if you were already appointed in the other state. We'll honor that in Texas, but otherwise it doesn't work. So you can't say, I want to be the guardian along with my other child, be co-guardian. That doesn't work in Texas. Okay. Successors. Oh, we've already talked about this. Specify who the successors should be. And if you
Or
know
should
that
not
someone,
be.
yeah, this is where you really need this document. If you feel like, if I'm not around, I definitely don't want it to be this person, then sign a declaration of guardian for my child, and you can specify who should not be a successor guardian. Okay. Michelle, I'm kind of whipping through these. You stop me when you need to stop. I know.
I think we're doing good.
Okay. I already mentioned that if you are appointed as a guardian, you still need to renew your letters every year. A guardian of the person does a simple report. You don't need an attorney to do that report. You can use an attorney, but it's very, very simple. And you just turn that in every year, and you get renewed or updated letters of guardianship with a new expiration date. You also need to pay a bond each year, but if you are a guardian of the person, in most counties around here, I'm in San Antonio, and in our end of Texas, it's never a problem. We can get a one-time fee bond where you pay $335. It used to be $375. It actually went down. $335, and that can cover lifetime bond. Does that make sense? So you don't have to keep paying it every year. Otherwise, you renew your bond every year. And in some counties, again, there's a court monitor or visitor that comes out. A guardianship can be modified or terminated. You can go back to court and say, when my child was 18 or 19, they couldn't do all these things, but now we want it modified. Maybe my child can now have their rights restored. That's a really wonderful hearing. The judges love that. I love to do those hearings. Or you could go back and just restore some rights. Let's say you wanted your child to get married after all, and they lost their right to get married. You could go to a judge and explain why you think this marriage is actually in your child's best interest, and the individual under guardianship could have that right restored. Okay. If you move to a new county or a new state, you have to move your guardianship. You're not going to have to go through the whole process again of establishing incapacity. That's the real expensive part of a guardianship, where you have an attorney ad litem appointed to make sure you're not removing rights unnecessarily. But even if I move from my county of Bayer County to Comal County or Travis County, I've got to move that guardianship to the new county. So there will be a very short court hearing, but you have to always have the guardianship in the right county.
Oh, this question was in the chat.
Okay. Can a guardian be a paid caregiver for the ward? So there are a lot of Medicaid waiver programs that are really important to families like mine and a lot of you, I'm sure, such as CLASS and HCS. In a lot of these Medicaid waiver programs, you cannot be a paid caregiver yourself if you're a guardian and you're trying to use the CDS option, but you can use an agency option. So if you are a guardian, you could still be paid as a caregiver, but you're going to have to go through the agency option. And if this is a little unfamiliar, basically CDS, it's just a little more flexible. I can manage, I don't have to clock in and out so carefully. It's just a lot more flexibility under the CDS option. That does not work if you're the guardian. Now, if I'm the guardian and I want to hire other caregivers, I can use CDS to manage those caregivers myself, but I can't pay myself or my spouse. Did that answer it? So and check
Yeah,
the
that's
specific
good.
Medicaid waiver program, but that's a problem with most of them. Okay.
So we have 3 minutes left. Allison, I'm just going to let you keep going. If you finish, great. If not, people will get the slides in their email later on today and a link to this recording. So just let me make that clear to everybody. And now you can go back to answering these questions.
Okay, we're just about done with the slides, but let me just mention there are a lot of special needs college programs out there that do not allow participation for someone who is under a guardianship. So you want to look at that. And there are many that have no problem with guardianship. But if you are considering having your child participate in a post-high school special needs college program, you want to find out, is there going to be a problem with participation if my child is under a guardianship? And what we have done in many cases for some of the programs near where I live in San Antonio, when we've done the guardianship, we've done a modified guardianship or a limited guardianship and allowed the ward to keep their rights to make educational decisions for a special needs college program and allowed them to keep their right to determine where they live. And so sometimes we can address it under the guardianship, but that's going to be dependent on your specific college program, whether or not they'll accept that. So that's something to look at if you're considering those programs. Why is the guardianship process so expensive? I've already mentioned all of these court costs. They just add up, the attorney ad litem, the actual fee to file it, the bond, it all adds up to a lot of money. The attorney's fees can range anywhere. I hate to say a number because attorneys are so different and depending on where you live, but it is going to be in the thousands. Okay. I know everyone kind of wants an idea. I would say typically you're looking at $5,000 or so to get a guardianship of the person that is not contested. So it is extremely expensive. There are some counties that have programs where you can do it for a reduced cost or no cost. And that again is going to be county dependent. So again, in Travis County, if you are very low income, there's a program where you're going to be able to get your guardianship without paying. In Bayer County, where I am, We have some Catholic charities will do a sliding scale. There's also the Morgan's Wonderland, or the Morgan's Multi-Assistance Center has a guardianship program in my county. So different counties have different programs. There's also Texas Rio Grande Legal Aid. There are some agencies that can help you do this cheaper, but if you have a good income and you're not going to qualify for these low income programs, you're looking at thousands of dollars. And so I wish I had a good solution for that. There was actually a proposal in the last legislative session to make guardianship much easier for parents of kids with developmental disabilities. And believe it or not, it did not pass. And the intent was to save money. And interestingly, Disability Rights Texas was very against that. And the reason is we want to make sure we're not removing rights of individuals with disabilities without a lot of protection in place. So, okay,
Well,
Michelle,
thank
go
you
ahead.
so much. We've answered as many questions as we have time for, and you've done such a great job. Thank you so much, Allison, for all this helpful information. If anybody wants to reach out to Allison, her contact information is in the slides. Our contact information at Consolidated Planning Group and kind of a little more about what we do is in the slides. You'll get those all later on today. You will also receive a link to the webinar on our YouTube channel. I hope I get to hear from you. It is a free Zoom consultation that we offer to talk about planning for the future. I hope everybody has a great day. Reach out if you need any help. Allison and I are here to help you. That's what we do. So if there's any further questions or concerns, reach out to us. Thank you all so much, and I hope you have a great day.
Thanks,
Bye now.
everyone. Thanks, Michelle.